The Supreme Court heard oral arguments over former President Donald Trump's eligibility to be on the 2024 ballot. The case hinges on the so-called insurrection clause of the 14th Amendment. The challenge comes from a group of Colorado voters citing Trump's involvement in the January 6th Capitol attack. Jessica Levinson joins us now for more analysis. She's a CBS News legal contributor and professor at Loyola Law School, who I was watching the minute the argument ended. So, Jessica, I'm glad to have you here so I can ask you all those questions I was asking when you couldn't hear me. I'm going to start off in the sort of complicated, which is, in addition to the 14th Amendment, there was a lot of discussion about something called the Griffin case. Can you tell us what that is and why that was discussed so much?
So this is a very old case that was decided by a former Chief Justice of the United States. And by very old, we mean more than 100 years old. But the reason it was discussed is because it dealt with disqualification and it dealt with a criminal prosecution, but it dealt with whether or not Congress has to provide guidance in certain areas. And that was what a lot of the argument was about here. Before a state like Colorado can throw somebody off the ballot, can say you're disqualified, do we first need to hear from Congress? Does there need to be a statute? We heard words like self-executing when they were talking about the Griffin case. What that really means is, can the state act like Colorado did and say, I'm looking at Section 3 of the 14th Amendment and Trump is not qualified? Or does a state have to wait for there to be a congressional statute, which is part of that Griffin case, and for Congress to say, states, you have the power, and states, here is some guidance?
And I'm going to come back to that in a second, but let me ask about another thing that was so much discussed, which is the idea that this wasn't a state power, as you said, that this might be something that Congress has to weigh in on. But states are given wide latitude to set the rules for federal elections. So how can states be given wide latitude to set the rules, but this is a rule that the state has to wait for Congress to tell it about?
Yes, yes, yes. So one of the classes I teach is election law, and there is this tension where, on the one hand, we do give states an enormous amount of power when it comes to designing election laws. We know that for people who have moved from state to state, you might have different voting ID laws. You might have different laws with respect to when you can vote, whether or not there's early voting, when you get your ballot, what the ballot looks like. But what the court said here is, we're talking also about the 14th Amendment. And the 14th Amendment, ratified in the wake of the Civil War, was in part about saying, states, we don't trust you. States, don't deprive people of equal protection. States, don't deprive people of life, liberty, or property without due process. And also folded into that is this idea of the 14th Amendment is about the federal government saying, states, we can't trust you. And that's, I think, why the court was able to say, yes, states get broad latitude. Yes, they get a lot of discretion in the election context, but there are certain places where we have to speak with one voice. There are certain places where we need national uniformity, and this is one of them.
Right. The spirit of the time when the 14th Amendment was created was not to give states more power or give it this great power, was I guess, raised by one of the justices. So, okay, let's go back to this idea that Congress has to weigh in. When do they weigh in, and how?
Well, this is part of the fun of being a Supreme Court justice, is that you don't have to concern yourself with those questions. I mean, I'm thinking in part of when you and I have talked about voting rights questions, where the Supreme Court has said, well, I'm sorry, but this case can't be successful. This is really for Congress if they want to write a different law. It's a different context, but it's the same kind of answer, where the Supreme Court doesn't have to draft that legislation. They don't have to provide specific guidance. They can basically say, not it. Us, the judicial branch, it's not us. And we're going to go ahead and push this to the political branches, which is, I think, exactly what they would like to do. There were interesting conversations also about Congress's ability to act when it comes to Section 3 of the 14th Amendment later on. So not just Congress saying, here's guidance to the courts, but the fact that Section 3 allows Congress, by a vote of 2/3 of the houses, to take away this so-called disability, meaning to allow a candidate to be qualified. And so lots of conversation about Congress's ability to act here.
And now I'm going right into the weeds for the last question, which is, there was that discussion of the 2/3 vote to take away the disability, but who puts on the disability? That's what confused me. There's no executing mechanism that puts on the disability, but they talked a lot about the one to take it off.
They did. And what was fascinating, and to your point, there wasn't a lot of tell me about the mechanism that puts the disability on in the first place. Instead, there was a lot of conversation about this is why, when it comes to requirements in the Constitution, barring somebody for engaging in an insurrection is different from saying you're not old enough, or you weren't born in this country, or you haven't resided here for 14 years. It's different because Congress can take that disability away. And so for Trump's lawyer, the argument was, so states acted too quickly because you've got to wait and see if Congress is going to take away this disability. But John, to your point, but who's putting the disability on in the first place?
And the disability in this case meaning being charged with having participated in an insurrection.
Or not necessarily formally charged, but somebody saying, Secretary of State or State Supreme Court, you engaged in insurrection, you previously held office, and you want to again.
CBS News legal contributor Jessica Levinson down in the weeds with me. Jessica, thank you so much.